So welcome everybody. We're so excited to have you in class today. Today's class is all about the Second Amendment. So we're going to dive deep into what the Second Amendment means, where did the idea come from, and why did the founding generation put it into the Constitution and in that Bill of Rights? And then what are the modern debates over the Second Amendment and its meaning of the words? So there's so many kind of key questions that we're going to dive through today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center. And I just want to encourage you all to ask questions as we go through this. We will be looking at the constitutional questions and the American history around this, but we really want to unpack our understanding and really hear perspectives from all sides. And to guide us through this learning journey is Tom Donnelly, our top constitutional scholar at the center. So Tom, thank you so much for being here. You know we'll have a lot of questions. I already, we list out all these million questions, but I thought it really kind of breaks down to the big question that's in everybody's mind. When can the government limit an individual's right to possess handguns or firearms, and when can it not? So I know there's so much history to unpack here, and we can start with the amendment, but there is still today, there's a big debate on this, and there's still some, I would say, lack of clarity around this as well. So maybe you can kind of tee us out with almost a modern discussion on it, and then we'll dive back into the past and where did it come from?
Yeah, absolutely. I mean, I think in a lot of ways, the modern debate, though, Curry, comes down to the question that you have right up on the screen right now. And it really does come down to how do we read the Second Amendment? And what does that say about an individual's right to keep and bear arms? And at the same time, the limits on the government's power to regulate firearms. And so it's at the Supreme Court this very term. There's a big case that's going to be decided by the end of June called New York Rifle and Pistol Association versus Bruin, which is going to deal with the individual right to keep and bear arms outside of the House. So this is as live an issue inside the courts. It's obviously one alive in politics as well. But as always, should we start with the Constitution, the text, Curry, and move from there?
Absolutely. And then the other thing but before we jump into that, the one other thing I want to kind of ping too is when we look at this, we tend to be so focused on the courts, but Congress plays a big role here when we talk about regulation and stuff like that. Congress plays a big role here. So as you unpack all of this for us, make sure we're understanding, what's your rights, what's your responsibilities, but also how does the court weigh in on this, and how does Congress weigh in on this too? So just adding more to your list in 30 minutes. But yes, let's start with the Second Amendment.
And I'll add even more to my list. There's also federalism. So it's not just the Supreme Court and the courts, it's not just Congress, but it's the state legislatures and local governments also play a key role in shaping the contours of gun laws. So we'll keep that in mind throughout our lesson today.
Yeah, and I think that's why this is so hard for people to understand and talk about, because it's extremely complex. So let's start making it less complex by looking at the words of the Constitution and then unpack them through stories in history.
Sure. So here's the text of the Second Amendment. It's pretty short, so we can read it. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so when lawyers look at this text, they really break it down into two separate parts. The first part, a well-regulated militia being necessary to the security of a free state, we call the prefatory clause. And so when we're reading this particular text, we want to keep in mind the historical context, which we'll talk about in a little bit. But this is really a text that's speaking to the founding generation's image of a state and local organized militia being essential to the security of America. And so it's really stating in many ways a key purpose for why we have a Second Amendment. Why was this so significant? Well, in part, the founding generation was really concerned about what they called standing armies, what we just think of today as professional armies. And they were concerned that if you had a large national government that had control over a professional army, that what history taught us was that leads to the abuse of our rights. And so for the founding generation, what they're embodying in this prefatory clause is one core purpose of the Second Amendment, the idea that we want American security to be organized, at least in part, around a well-regulated militia. So that's the prefatory clause. The second clause, which is probably the most famous part of the Second Amendment, we call the operative clause. And that's the right of the people to keep and bear arms shall not be infringed. And so here what we're speaking to really is, a core right of the people. And so this is a core right and what is the right? It's to keep and bear arms. And so as we're projecting forward, Curry, into the constitutional debates that go all the way up to modern cases like Heller and McDonald's, a lot of those opinions by dueling justices come down to, how do you read these two clauses? How do they operate together? Do we say that the prefatory clause about a well-regulated militia should limit how we read the rights that it's embodied in the operative clause? And so do we really think the Second Amendment is really about there being a well-regulated militia with those rights closely tethered together? Or is the Second Amendment best read as expressing a broad right of the people to keep and bear arms, and the prefatory clause is then just one reason among many why we have it in the Constitution? That question, in many ways, sort of the scope of the Second Amendment's power and the scope of the power of government to regulate firearms in this country turns in part on how we, and especially how the justices, answer that question.
Thank you for laying that out so clearly, because, and we'll get into what, you talked a little bit about why we have these two parts in there to begin with, but it also is just really refreshing to hear. And this is why we're still debating it today, because there's two parts and groups can say it's part A more than part B, and other groups can say it's part B more than part A. So it really kind of helps understand why we're kind of at odds here. So maybe we should really understand, what they were thinking and how they were writing it at the time of the founding. And you started talking about this, we always go back to, they're adding the Bill of Rights after the Revolutionary War, and they have lived experiences of what it was like in the colonies when they had a national government that was too much. And this is what their big worry is about, is like, again, going back to having the British Army kind of overtaking them and having no rights. I don't know if you want to dive into the Third Amendment here, even though I joked and said we really don't talk about the Third Amendment a lot. We could today if you wanted to, but maybe give us leading up to the Constitutional Convention, and then we'll dive into the convention and what's around this idea of militia, standing armies, and the Bill of Rights.
Sure. So, to frame the two big lessons that the founding generation's learning from this experience, I sort of flagged them at the beginning, but I want to emphasize them again. One is that many members of the founding generation, because of the experience of the colonists and because of the American Revolution, were suspicious of standing armies, this being professional armies paid by the government and separate from citizen militias. And the second big lesson they learned was that many members also valued citizen militias organized by state and local governments, led by local leaders, and comprised of local community members. And that's how they wanted national security to largely work in America. Now we look at this and we say, why were they so afraid of standing armies? Part of it, as Curry already flagged, was that their experience in colonial America. So what happened during the American Revolution, and even right before it, leading up to it? We were occupied by British troops. The British troops were here, and they really felt to the colonists like an imperial occupying presence, especially in a place like Boston, where we had many of the most rabble-rousing patriots. What did the British Empire do? They cracked down on the rights and the right of self-governance of the Bostonians, and they sent a ton of troops there. And so Boston at the time had a population of around 16,000 people. By 1775, the British stationed 4,000 soldiers there. So that's 16,000 Bostonians, 4,000 British soldiers. That's more than sort of the able-bodied folks that Bostonians that could have been troops. And so it's really just a massive military presence. And so when the founding generations thinking about standing armies, they're thinking about the British troops in this specific context, where you have sort of British troops everywhere, harassing American colonists, abusing their rights, at times because of the British Quartering Acts, perhaps having to house soldiers in their homes. That's why we have the Third Amendment. The Third Amendment says that we can't be required to quarter soldiers in our homes. That grew out of this experience, especially in colonial Boston, but this experience with the British troops on our soil. We can see this concern in the founding generation. It was expressed in the Declaration of Independence that charged King George III that, quote, kept among us in times of peace standing armies without consent of our legislatures. So growing out of this colonial experience, growing out of the American Revolution, there's this concern that standing armies are going to abuse our rights. And it's not just this experience with the British, but for someone like Madison, who also studied history, he could look back at the ancient republics and throughout all of world history and see, what do tyrants do? They rely on military troops to oppress the people. And so here, there was a sense that we don't really want to go down that path of having a massive military establishment. We want certain protections in place to avoid that.
Yeah, it is a very different mindset that we have about the military, that we see that the military as like, at least many people in America see the military as like peacekeepers or freedom fighters. But this is the opposite, is seeing it as this is how a despot leader can control the people and suppress the people's voice, agency, and ruling. Mandy asked a question, like clarification on some of the words. So why only a free state, and don't all nations require a militia? Can you talk a little bit about what is a militia and what is an army? Like just so clarification of those words, because people do use them all the time interchangeably, and they are different.
Yeah, so in this context, when we're talking about an army, we're talking about really professionals. These are people that are serving in the armies and they're paid by the government. And this is separate from a local citizen militia. At the founding, these were seen as people who were mercenaries. They were paid guns for hire. They're willing to basically go anywhere and be disassociated from their local communities. Where at the same time, a militia in this context, it wasn't just a freestanding private militia of people just getting together with firearms to protect one another. It's something that's organized by state and local governments. You have local community leaders leading the militia companies and members of the community, broadly able-bodied people in the community serving in the militia, with the idea that it's something that's separate from the net, especially in this context, from a national government establishment, and it's something that's really rooted in the local communities. It was rooted in sort of a broader ethos of what they would have called civic republican virtue. And this idea that we, members of a free state, so members of a republic, like America, like what we want to be, part of what you do is that you value the common good over your private self-interest. And part of the way in which you're going to serve the common good is for when necessary and called upon to protect your community.
Cincinnatus, that's a great reference there. Like if you're a farmer and when your country needs you, you stand up and you fight for your country. And then when it's over, you give your guns back and you go back to being a farmer. So this idea of a free state, and it's not just a state. Think of it as like a free country or a free organization. I think this is a little reflective of what's going on in Ukraine too. It's interesting to see kind of these mixes around it too. So now let's jump into the Constitutional Convention. And I know we want to kind of move through time pretty quickly here because we have a lot to cover, but there are references to this in the structural constitution, not just in the Bill of Rights. So maybe walk us through the convention, what they talked about, what they worried about, and then we'll jump pretty fast to Reconstruction.
Yeah, so I mean, as we're plowing towards the convention, there's a few things to note. So one is that we get out of the colonial experience this fear of standing armies, of a massive military establishment in the national government. But many in the founding generation, people like George Washington and Alexander Hamilton, were also concerned, though, that one of the lessons of the American Revolution was that our national government didn't actually have enough power to keep us safe, and that maybe citizen militias alone with no guidance from the national government weren't enough to ensure American national security. And so as we're going towards the convention, we have state constitutions that speak to some of these issues, protecting things in some of these state constitutions have provisions protecting an individual right to keep and bear arms for self-defense. Many state constitutions speak out against standing armies and in favor of militia duty. But when we get to the Constitutional Convention, part of what the founding generation is trying to do there, their big goal is to create a government that's more powerful than the national government created by the Articles of Confederation, but also one of limited powers. When it came to firearms and when it came to national security, what the Constitution actually does are two really big things. One, it actually gives the new national government broad national powers to establish a peacetime standing army. So in this sense, the Alexander Hamiltons and George Washingtons of the world win. This new national government has power to raise an army and navy. The other is that it gives the national government power to regulate the state militias. And so with this new national constitution proposed in Philadelphia, what you have is a massive growth of power in the national government to give the national government power for really the interests of national security. And so you can imagine how certain other critics of the Constitution would respond based on the colonial experience. At the convention itself, you have three dissenters at the end of the convention: Edmund Randolph, Elbridge Gerry, and George Mason, refusing to sign the new Constitution. What's one of their big complaints? Well, for Gerry and Mason, is that there's no protection against standing armies. They're essentially saying, have you learned nothing from our experience with the British Empire? And so as we get into the debates over the ratification of the Constitution, pitting the Federalists in support of the new Constitution against the Anti-Federalists opposed to this new Constitution, the Anti-Federalists echo the arguments of Mason and Gerry and say what we're seeing with this new national government is a consolidation of all power to the national government and the threat of a destruction of our liberties. One of the reasons we know this is because this new national constitution gives the national government massive power to create a standing army and to regulate the militias. Something has to change. In response, Federalists like Alexander Hamilton effectively say, yes, what you say about the British Empire is true, but grow up. We're going to be a great nation. And one of the things great nations need to be able to do is to create a national military to keep us safe. And then you had finally James Madison, as always, trying to sort of broker that compromise between the two, saying, on the one hand, yes, it is true that we need peacetime standing armies. But yes, in America, we can also base a lot of our security interests in a well-regulated militia. There's a great virtue in having citizen-led local militias really there to protect our liberties and to protect our communities. And so that's effectively framing how we get to the Second Amendment, Curry.
So, and thank you. And I love always Hamilton being like, oh my God, get over yourself. And like, let's move on to the future of what will be, because he always had such a grand and huge vision. But the dissenters aren't wrong, and they're worried for really good reasons. And we get to that Second Amendment. The only thing I want to kind of to bring up at this time is there's definitely references to insurrections in these debates and in these conversations. So it's not just the fear and the worry, which is so true at this point in time during the Constitutional Convention. You've got, Spain and Britain basically like blocking our waterways and picking off sailors from our boats. So they're knocking at our door. So there's a really good reason why Hamilton's saying this is so important. But they're also talking about insurrection. So can you unpack what they mean by that too? Are they worried about Shays' Rebellion, or are there other insurrections that they're referencing?
Well, it's a variety. Yeah, I mean, part of what they're concerned about is mob violence. So Shays' Rebellion was this uprising of farmers in Western Massachusetts, and there's this concern with needing to have the power to put down rebellions like that. If you go down to something like the Virginia State Ratifying Convention, you also have concerns expressed by delegates like George Mason about insurrections from enslaved people. And so a concern that with the new national government, maybe this new national government with so much control over militias, maybe they're not going to protect us if there is enslaved people in insurrection here in a place like Virginia. And so it ends up being a real variety of interests. And there's real live debate among scholars about which of these goals, was most important in the Second Amendment. I think the thing that's fair to say about the Second Amendment writ large, and you can see this in our interactive Constitution essay from scholars from both sides of the political spectrum, is that the Second Amendment really does very little to take away powers from the national government to raise a standing army or to in many ways regulate the state militias. But what it does do is it takes away one core concern of the Anti-Federalists, which was a concern that the national government was going to disarm the people. The Second Amendment takes that threat away. The national government clearly does not have power to do that in this context. And as a result of that, the local citizen-led militias are protected from at least that part of what the national government could do.
Cool. Okay, now this part of the historical timeline was always a big eye-opener for me. So we first talk about this worry that the federal government is going to suppress the people. And that's why, we put in the Second Amendment. Then after the Civil War, and really after Reconstruction ends, it starts to shift and change the way that our society talks about the Second Amendment. And instead of saying, I'm worried about the federal government, it's almost like I'm worried about the government not protecting me and me have to protecting myself. So can you tell us a little bit about how the end of Reconstruction, and even during Reconstruction, the end of the Civil War, it starts to change for people and the protection of self?
Yeah, of course. I mean, there is this massive transition in how people view, especially a national military. And so, in the founding generation, it's all about a threat to the rights of the people. But so many Americans after the Civil War view the national military as key to protecting their rights. And so there's a shift in that sense. There's also a shift to concerns about private militias maybe being a symbol of extra-legal violence, especially in the South after the Civil War. And it's a reminder that the Civil War, Reconstruction, and our nation's second founding really reshape a lot of debates over firearms in the United States in important ways, and especially for the African-American community. And so what we see, after the Civil War, we see this wave of laws passed by white Southern governments called the Black Codes, which are designed to try to put African-Americans as much into a situation like the institution of slavery as possible after emancipation. And one of the things that the Black Codes takes away is the right of African Americans to have firearms, including many African Americans who would return down south after serving in the Union Army to defeat the Confederacy. And so you see a range of voices at the national level saying, one, in a broader sense, the black codes have to go. Nothing flies more in the face of what we accomplished through the Civil War than these black codes. So we need the national government to sweep away these black codes and to protect the rights of the formerly enslaved people. And you see people like Frederick Douglass saying it's the national government that has to do this. Part of the vision is tied to the need for African Americans to have firearms to protect themselves, because they can't rely on their state and local governments to protect themselves, their families, their neighbors, all of the people they care about. And so here you see Frederick Douglass saying the black man has never had the right either to keep or bear arms, and the legislature of the states will still have the power to forbid it. And so you see Frederick Douglass, you see conventions of African Americans meeting throughout the nation, laying out their vision of what is necessary for them to have a new birth of freedom and equal citizenship in America. And part of what they say is that they need to have their right to keep and bear arms just as much honored as white Americans. And so that's in part what they're calling for there. And so we see in some of the landmark legislation passed after the Civil War during this period of Reconstruction, recognizing the importance to protect the right to keep and bear arms of African Americans. This includes the Civil Rights Act of 1866, which is the nation's first civil rights law. It's part of the Freedmen's Bureau Act. And we also see it in debates over the 14th Amendment itself. And maybe the best quote to sort of capture this vision from the African American perspective happens decades after the ratification of the 14th Amendment. So the 14th Amendment's ratified in 1868. And by 1892, you could see Ida B. Wells here explaining the importance of this shift in the importance of firearms to the African American community in, really, this is the beginning of the real growth of Jim Crow throughout the South, and she's explaining the importance of firearms. A Winchester rifle should have a place of honor in every black home. When the white man knows he runs as great a risk of biting the dust every time his African American victim does, he will have a greater respect for African American life. And so what you see here is what we can pull from the original founding is this strand talking especially about the importance of the militia and the importance of the militia to community safety. And what we pull from the experience of the Civil War, Reconstruction, and America's second founding is somewhat of a shift in how at least certain Americans think about the importance of firearms, particularly its centrality to the protection of African Americans throughout the post-Civil War South.
And we're just commenting in the chat about how powerful this statement is by Ida B. Wells, and knowing like the work that Ida B. Wells does, to stop lynching, to stop the murder of African Americans across the country, not just in the South. But this really brings us to, like, we can, and not to, tell horrible stories, but let's tell some horrible stories. We can talk about the Tulsa riots and the Tulsa massacre, and go back and think about that standing army and saying, what about that standing army, a group of people trying to protect themselves and the local government not protecting them, but also just lead us right into the Colfax massacre and then the courts and how the courts do not stop this violence either. So maybe go to Colfax to Cruikshank, and then we'll jump into more modern conversations around the Second Amendment, because there's lots of pivots in the storyline and lots of layers to it. So we want to unpack a few things here.
Yeah, so the Colfax massacre happens in April 1873. It's one of the most massive examples of violence against African Americans in the post-Civil War South. It's in Louisiana. You have the two parties both saying they won the election of 1872. And so both parties are trying to take control of the Colfax courthouse. And Republicans, including many African American Republicans and their allies, end up taking control of the courthouse. They bring firearms with them to protect themselves. They're attacked by a white mob, and the white mob sets the courthouse on fire. And ultimately, more than 100 African Americans were shot and killed. Many of them as they fled the courthouse. This is a major prosecution of the Grant administration. They go after the leaders of the Colfax massacre, including William Cruikshank. It culminates in this case, Cruikshank versus United States. The leaders of the Colfax massacre, they're actually convicted. So they are convicted under the Enforcement Act of 1870, and the Supreme Court, in a unanimous opinion, throws out their conviction. And it says really two big things. One, Congress didn't have the power to pass this particular law because it's going after the actions of private individuals, not actions of a government. So this is known as the state action doctrine. That's a technical point. The other is that the Supreme Court says that the Second Amendment doesn't apply to the actions of the states. It only applies to the national government. And it does raise something that's very interesting about the Second Amendment, Curry, and that's that the Supreme Court actually decides really, really few cases about the Second Amendment from when it's added to the Constitution in 1791 all the way up to the Heller decision in 2008. There are just very, very few decisions where the Supreme Court is saying much about the Second Amendment. And Heller itself in 2008, in many ways, is the landmark ruling that exposes, one, it sets the rules under constitutional law, but it also it shows the debates on each side because it's a case that's a 5-4 decision.
Yeah, and thank you for making that jump from one to the other. And just on a side note, that's Clark Neely right there on the right-hand side, which I always missed him in that picture. He's going to be our guest on Friday, and he was on the Heller case. So we don't have to vote on this, but the question really in the Heller and the McDonald case, and we'll talk about that, is can a city effectively ban handguns within city limits? Tom, as you walk us through there, I just want to add to it, what are the rulings around schools too? So maybe kind of hit both of those as you tell us the story around leading up to Heller and then McDonald.
Yeah, and so, District of Columbia versus Heller comes first in 2008. It's about this DC, a law that effectively bans handguns in Washington, DC. It's one of the most strict gun control laws in the country. And it raises that question we asked at the beginning, which is how do we read the text of the Second Amendment? Do we read it as something that really, really has to do with citizen-led militias and restrict the right in that sense? If that's true, then governments at all levels have a lot of authority to regulate firearms. Or do we say that the Second Amendment is really an expression of a broader individual right, one that for many people even precedes the Constitution, that it's a natural right of all people, and that it's very broad, and as a result, people can use the Second Amendment to challenge gun laws throughout the country and at times win. But ultimately, the Supreme Court in a 5-4 decision sides with that second view, with the idea that the Second Amendment protects an individual right to keep and bear arms, and it strikes down, so it declares unconstitutional this DC law. And so, in the end, what the key ruling in Heller is that the Second Amendment protects an individual right to keep and bear arms for protection in one's home. It's predominantly about the importance of self-defense in the home, with a lot of later questions that we have to then ask about how much does that ruling travel? How much does it affect firearms outside of the home, regulations of that? How much does it affect the banning of firearms in certain sensitive places like schools, like government buildings? How much does it affect bans that are long-standing for certain people, bans on firearms for, say, the mentally ill, or for felons. And so in the case of Heller, it's really about the individual right to keep and bear arms in the home. And what Justice Scalia says is he really does a close reading of the Second Amendment's text. And he says, really, there's nothing about keep and bear arms that just has to do with militia service. At the time, if you look at the dictionary, that those sorts of words could be used in the context of an individual right to protect oneself or one's home. If you're looking at how do we read the text itself, he says, if you look at the use of prefatory clauses across a lot of different texts in the law and in constitutions, the prefatory clause saying about the well-regulated militia doesn't necessarily restrict the right to keep and bear arms. It could be the expression of just one purpose among many that we find for protecting firearms in the Second Amendment, like an individual right to keep and bear arms. And finally, if you look more broadly at the constitutional tradition at the founding, you can see in state constitutions many examples of there being protection of an individual right to keep and bear arms. And so it's natural to think that this might have been a broadly held view at the time. Justice Scalia, though, is countered by a very powerful dissent by Justice John Paul Stevens, who offers his own reading of the Constitution's text and history. And so here we see two opinions, both taking an originalist view, trying to look at what did the Second Amendment mean when it was framed and ratified. What Justice John Paul Stevens says is, no, Justice Scalia, you're reading the Second Amendment the wrong way. The most natural way to read the amendment is to say that the prefatory clause should inform what is the nature of this right. And so here, what we really have to do is read the Second Amendment as an amendment that has a lot to do with the citizen-led militia. It doesn't have to do with an individual right to keep and bear arms. Why should we think this? In part, it's because when Madison's framing this Second Amendment and other people are considering whether to ratify it, There are a range of ways in which they could have written it. There were a lot of other texts circulating in state constitutions and proposals from the state ratifying conventions that spoke more clearly to an individual right to self-defense. They didn't choose that text in the Second Amendment. As a result, we should read it in a way that limits its protections to citizen-led militias. And because of that, Justice Stevens concludes the DC handgun law is constitutional, that it can stand.
So I appreciate you weaving in the methods there. So students, if you've ever come to one of our methods class, Tom did just a great job showing the methods they use to write their argument and just to prove their point. So thank you so much for that. One piece of clarity when we look at this and we understand Heller, because I've had this question before, and the question was like, oh, so people are allowed to have handguns, period. Heller decided that. And it was very like a blanket statement. And the real conversation is how much and where can the government limit or not limit guns? So there's always been limits on, like you just said this a minute ago, there's always been limits on firearms, the types of firearms, who can have the firearms, and that still holds true. And whose role is that? Is the real question how much and in what locations?
Well, yeah, I mean, Heller itself is very clear that there's a Second Amendment individual right to keep and bear arms, but that like every right, like the First Amendment rights, that no right is absolute. And so a lot of what the Supreme Court has to do, so the work it did in Heller, and also in its companion case, McDonald versus City of Chicago, just taking a quick beat on that, what McDonald did was it effectively, Heller was about a law in the District of Columbia. District of Columbia is a federal territory, so the Second Amendment directly applies to Washington, D.C. What the McDonald case said is, okay, well, does the Second Amendment then apply to state and local government? So it asks that natural question, what lawyers call incorporation. And that's this question of whether the 14th Amendment applies those protections of the Second Amendment against state and local governments. The Supreme Court in a 5-4 decision said yes. And so if we take Heller and McDonald together, the big things that it settles a core principle. So it says the Second Amendment protects an individual right to gun possession for purposes of protecting one's home. It also begins to set some boundaries on the Second Amendment. So both the DC law from Heller and the Chicago law that was at issue in McDonald were among the strictest gun control laws in the country. And so what the Supreme Court was saying was, as to those very particularly strict laws, those have to go. But the court also was clear that there are, that the Second Amendment, like all other rights, those rights are not absolute. And so Scalia specifically says in his Heller opinion, he acknowledges longstanding prohibitions, quote, on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of firearms. And then it also affirmed the historical tradition of prohibiting the carrying of dangerous and unusual weapons. So this is the idea that the Second Amendment may protect your right to keep and bear a handgun for the protection of your home, but you can't have a bazooka. Like that's kind of what Justice Scalia is saying there in Heller. And so this raises all sorts of follow-up questions, Curry, that the courts are going to wrestle with for years to come. Like this moment for Second Amendment case law is not unlike where we were with the First Amendment 60 years ago. So there's going to be a lot of work that has to be done to figure out, which regulations can stay, which can go, how broadly should the right be protected. You have some justices like Justice Thomas, Gorsuch, Alito saying that, look, we decided Heller, we decided McDonald, the lower courts now are treating the Second Amendment as a second-class right. They're upholding all gun laws. And so we, the Supreme Court, probably have to step in and say, no, you have to have a broader view of the rights protected by the Second Amendment. You have others, other people disagreeing, other scholars, especially and justices disagreeing with those justices saying, no. If you look at a context like something like the First Amendment, what you'll see is, over time, the court has developed a lot of rules around those protections. In some places, the protection's really, really, really broad. In other places, like with the First Amendment, even like in the context of a school, there are regulations you could do on speech in the context of a school that you can't do in other places. And so maybe there's a way over time with the Second Amendment, we'll develop a similar set of rules for different contexts. And so it's just the absolute beginning of how we're developing this area of the law. And again, just a flag for those of you who are really interested in this topic, keep track of the case New York Rifle and Pistol Association versus Bruin. It's before the Supreme Court now. The arguments have happened. The opinion's probably going to come out by the end of June. So really, really soon. And it asks the natural follow-up question from Heller and McDonald, which is, does this right that you found of an individual to keep and bear arms from the protection of one's home, does it travel outside the home? And so it's asking especially how the Second Amendment applies to a permitting regime in New York for people who want to be able to carry concealed weapons in public. That's the question.
And I love the idea that this conversation is, we're looking at federalism at the state level, at the national level, but it's also like you're in the middle of that moment of creating rules, boundaries, and limits and opportunities in this law and in this understanding. So Tom, thank you so much for kind of breaking it down for us, trying to help us understand what has been the debate, what has been the stories behind the Second Amendment and the reasoning behind the Second Amendment, as well as the modern conversation and understanding that it's not without limits, but where the limits the courts have set boundaries on those, limiting the right to a firearm as well. And whenever we can talk about bazookas, it will always make me smile as well. So thank you for using that word. So we have 2 follow-up questions. What I'm going to do is just shut down the recording for everybody. So students, if you have to jump, we understand. If not, I'm going to follow it with 2 class questions real fast.